All righty. So good morning, everybody. It is 10 o'clock on May 15th, and we are going to talk about time being of the essence in your contracts today. I'm very excited about this topic because it comes up quite often in the context of the negotiations over provisions in the contract and then enforcing them throughout the term of the deal. Of course, because I'm an attorney, we have to start with a disclaimer that I'm providing you information only, and we have not established an attorney-client relationship. So please don't sue me. So a little bit about me, of course. I am a member of the NABOR Legal Resources Committee and a member of the Joint Committee on FAR/BAR Contracts. So I work on both sets of forms that you're likely to be using in your real estate practice. I've been a lawyer for 20 years. I've done a lot of this. So the other thing I always like to mention is that we have a title company, Paradise Coast Title and Escrow. So if you ever need escrow services and your customer does not want the services of an attorney, we can still help them with their closing. Just give me a call and we'll get you taken care of. A little bit of time is of the essence. It's in most contracts, the term in most contracts, and the question of what it means and how it affects the party's rights under the contract is what we're going to be talking about today. How does having a time of the essence clause make your contract better or worse? And really there are two kinds of clauses. Either if you have a clause at all, which you are not required to have time of the essence clauses, they can either be universal or limited. And a universal clause is what you think it means. It applies to all deadlines in the contract, or it can be limited and apply to some deadlines in the contract, such as like the closing date, but maybe not the deposit date, which those of you that use the NABOR forms would be familiar with. If time is of the essence provision applies to all terms, then each party is given the immediate right to cancel if the other party fails to perform within the time stated. Where time is of the essence as to, like, say, only a closing date or a limited clause, then time is not of the essence as to other deadlines in the contract. But be careful, because if there are other provisions in the contract where a performance is due by a certain time, you may not be able to immediately terminate, but you would give up certain rights. So it's going to get a little confusing as we go through this, but I hope to explain it all to you much more clearly. But basically, if it applies to all provisions, you don't have to give a notice of termination. The contract just immediately terminates. In NABOR contracts, time is of the essence as to the closing date. It's a limited clause. It only applies to the closing date. For other dated provisions like inspections, there may not be an immediate right to cancel, but there are still rights and consequences for missing those written dates in the contract. And we'll talk more about this. Now, FAR/BAR's time of the essence clause says time is of the essence in this contract. That is a universal clause. It applies to all of the dates in the contract, and parties need to be very aware of their dates and their timelines. And we'll talk more about that in a second. Before we get into the consequences of the timeline, let's talk about the specificity requirements. When including a time of the essence clause, you have to state a particular time or date, like the closing date or deposit due date. If you have a particular date of performance in the contract, it does not automatically make time of the essence. Again, it has to be expressly written. And if there is no time of the essence clause and one party misses a deadline, then you have to notify the other party and give them a reasonable opportunity to cure. So when time is not of the essence, there's an opportunity to cure. But again, let me just say this first. When you think about like a missing a deposit deadline in the NABOR contract, you would send a notice to the buyer, hey, buyer, you missed your deadline. You have 1 business day to get your deposit into the escrow agent. If you don't do that, the contract terminates. And of course, in NABOR, if it's a first deposit, then there's no consequence to the buyer because the seller is limited to deposits that are already made. Gets a little intense when it comes time to missing deposits, and we definitely want to make sure that we're staying on top of our buyers to get those deposits in. It's also possible to waive time is of the essence. But if the contract does say the time is of the essence, like the FAR contract or the NABOR contract for closing, then you actually do not need a notice of default. The party is automatically defaulted, and you do not have to give an opportunity to cure. They've missed their deadline. And the courts are very clear on this. I've been going through the cases this morning and yesterday, just making sure that this point was correct because it seems so harsh. But I've got 1, 2, 3, 4, 5, 6 cases, 7 cases going back to 1896 that basically say you miss the time of the essence deadline, you're dead in the water. And the courts have been clear about this, and like I said, consistent since 1896. The other thing the courts have said is that if you do extensions, for example, so say the closing date, which is time of the essence in both contracts, gets extended 1, 2, 3, 4 times, that does not waive a time of the essence clause. So if after the 4th extension, the seller says no more extensions, and then the buyer misses again, contract terminates, and the buyer is in default. There's other cases that say that when you fail to assert the clause, it constitutes a waiver. So there was a case that said that the buyer had missed the closing date, and or missed the deposit date, and the court said, well, you let them do the deposit later, so you waived. That makes sense. If you let them continue their performance, obviously you want the deal to go forward, even if it's not formal and in writing. The courts don't like to terminate deals. They don't like forfeitures. There's case law that says that courts abhor a forfeiture. So they try to be very careful and very narrow in their construction of these cases. So talking about a seller extension for a second, buyers can request and sellers can grant an extension to the closing date, but then the time of the essence clause applies to the new date. It does not go away just because the parties agree to a date change in advance. Just be cautious of that. What happens with what is the effect of the deadline? Even if there's no time is of the essence, the contract still has consequences if parties miss deadlines. Usually there's a window of time in which the non-breaching party must respond, and many times non-breaching parties have to notify the other party. But if you think about, for example, in the NABOR contract, you've got the inspection deadlines, 15 days to make your inspections, 5 days to report them, 10 days for the seller to reply, 5 days for the buyer to terminate. If the buyer does not like the response they receive from the seller with regard to an inspection election. So what happens, for example, if you have a 15-day inspection on your contract and time is not of the essence as to inspections, but the contract under NABOR says you only get those 15 days. Well, on the 16th day, the seller does not have to notice the buyer, hey, your inspection period is over. You don't get to come back in the property. No, it's automatic in the contract that the buyer gets 15 days for the inspection. And if the 16th day, they can no longer go back in and conduct an inspection in the property. So you just have to, even though time is not of the essence for every single deadline in the NABOR contract, time can still be of the essence to perform under the contract. What really matters in NABOR, again, is the deposits. And in FAR, every deadline is of the essence, so you can't miss any of them. Now, this is an interesting case. This is a very, very strange case, but the Delta Mobile Homes case from 1973, I found it and I was reading it and I checked it and it's still good law. It's been cited. But if the agent interferes with the ability of, in this case, the buyer to perform and get a loan under the contract, this time because the agent took documents from the buyer and refused to return them. The court found that the seller had to give the buyer a reasonable opportunity to close the transaction because it was the seller's fault through their agent that the buyer could not perform. So there's got to be no culpability on the side of the agent to side of the, I should say, on the side of the seller to hinder the buyer's performance. And that, my friends, is time of the essence in a nutshell. I'm willing to take questions now. Does anybody have any questions? I see, Rosemary, you're on here. You always have questions.
Not today, Sam. I get it. I put my when I write a contract, I put all the times in my calendar with alerts so that I can get them out in a timely manner.
Well, if we could talk about best practices for a moment, that actually is an excellent best practice. I hope everybody on this call does that. Put them in your calendar or use a program if you've got one. I think I personally just put the deadlines on my calendar as well. You don't want to be the agent that misses the deadline because you didn't understand time is of the essence. You don't want to be the one that's to go to your customer and say, listen, you just lost a $20,000 deposit because we had a mistake in the process. So you definitely don't want to be in that spot. Other questions? Anybody? Marianne, I see you're unmuted. Anybody?
My only other comment is make sure that everybody actually reads the contract.
Well, that should be implied. I could do a whole class on, and it'll be 1 minute long, and it would say, read the contract.
Just read the contract, understand the deadlines, educate your customer on them, send them an email.
Yeah.
Just read the contract. You'd be surprised how many agents don't actually read these contracts.
Right, and that's a really good advice. Everything you really need to know about your closing is in the contract. It really is. The whole escrow process, the deadlines, the rights and responsibilities, it's all in there. Nothing is assumed. And when it's not in the contract, it's covered by statute, which of course is tougher to know, but as an agent, you are charged with knowing it. I would just point one last thing out with regard to timing is of the essence. If you miss the deadline and you're scrambling, the courts in equity, they don't like a forfeiture. So if we can come up with any reasonable, rational solution short of breach of contract and suing everybody, we should work towards that. So and I don't know how many of the agents of you guys have survived like the hurricanes, but especially in Southwest Florida, all of us working together to get closings done so we all get paid is really kind of the goal. So just be careful. Just be careful there. Don't be too harsh on these deadlines if you've got don't kill the deal. That's my point.
Hey, Sam.
Yes.
Could I, this is Mike. Could I add one thing too?
Yes,
One
Mike.
of the biggest things on deadlines is that looking at the calendar also before you set up the contract, before you write the contract from the buyer's agent standpoint, because so many times, like, counting it out and figuring it out, the deadlines are set up on a weekend or a holiday, and it does cause a lot of confusion for folks. So just planning that out can really help a lot when you're thinking about deposit dates and inspection dates and financing contingency dates. It just can really, I think, ease the tracking and create a lot more clarity by doing that up front when you're planning.
I totally agree. You should definitely look. Now, the contract does cover you, of course, as you know, if you have a deadline that falls on a weekend or a legal holiday as defined under federal statute, it rolls to 11/59 on the next business day in both the FAR bar and NABOR contracts. But the the better practice, the best practice is really to look at your dates up front and understand where they're going to land so that you're not arguing about them later. The other thing I would say, just with regard to the statutes, the federal statute on vacation days or holidays, is there's 11 of them. So be careful. Like there's a lot of like Florida holidays that don't count that people think count. So be careful about that as well. Other questions anybody's got? Nobody has any questions? Okay, so this is one of my shorter webinars, and I'm going to be trying to do more of these shorts so that people can jump on and listen and then get back to their busy day. We got some more coming up, so stick to your emails. And I really thank everybody for coming out today. If you've got any questions, you can call or email me anytime. My contact information is on the screen, and of course, available pretty much all social media channels. So thank you all very much, and we will call it closed.